Hello, government students. Today we're going to talk about the Illinois judiciary, the judicial branch of our state government. The information on the judicial branch is covered in Article 6 of the Illinois State Constitution. In this picture we see the Illinois Supreme Court in their court chambers. That, of course, is also in Springfield, Illinois, where the rest of our state government is headquartered. So without further ado, let's go ahead and get started on the state courts, the judiciary. So, what is the purpose of the judicial branch? You probably will recall that the judicial branch is involved in the interpretation of the law, and I'd take that a step further. It's to interpret the law and administer justice. So that's the purpose of our judicial branch. So let's get into some of the details of how this works. First of all, we have state courts, but we also have federal courts. Federal courts are courts that are managed by the United States government. So the thing is, there are more state laws than there are federal laws. So if a state law is broken, that case would be heard in a state court. If a federal law is broken, that case would be heard in a federal or United States court. And you are going to have a lot more court cases heard in state courts than federal courts, since in fact there are a lot more laws that are state laws versus federal laws. For example, your basic law against robbing a bank, that's a state law. There is no federal law that prohibits robbing a bank. But of course, every state has laws that would prevent you from doing that. But any case that involves robbing a bank is going to be heard in a state court because those are state laws. If a crime involves both state law and federal law, you could conceivably have the same crime tried in both a state court and a federal court. In other words, you could have the case heard twice, both at the state level and the federal level. That does not mean that there's double jeopardy involved, because the state court is going to be trying the case in the sense that someone broke a state law. Well, if there's also a federal law involved, the courts will also try that case in a federal court for the federal aspect of that law. Double jeopardy will apply if you are found not guilty in a state court. You cannot retry the same case in a state court again, but that case could be retried in a federal court, since that would be trying the case based on the federal law that was broken. I'll give you an example of this kind of a deal. Back in the 1990s, some domestic terrorists set a bomb off in Oklahoma City and blew up a federal building in Oklahoma City, and it killed about 250 people. Until the terrorist attacks of 9/11, this was the most heinous terrorist act ever in the United States history. It killed more people than any other terrorist attack in our history until 9/11. Well, the perpetrators of that crime committed a state violation, of course. They murdered people by using a bomb, so they were tried in state court for murder, but they also broke federal laws. There is a federal law against engaging in some kind of attack against a federal United States-owned building or facility. So by bombing a federal building that happened to be in Oklahoma City, those terrorists also broke a federal law. They were tried at both the state level and the federal level. And one reason this, I think, made sense is because, let's say that they only were put on trial at the state level. If for some reason there was not sufficient proof, perhaps, that these people did in fact commit this terrible act, or perhaps something went wrong in the trial, but due to a mistake on the part of the prosecution, perhaps the trial would have been declared a mistrial, and these murderers could have gotten off. Well, by also trying them at the federal level in federal courts, it helped to ensure that the perpetrators of that crime would be punished. It was kind of like an insurance policy almost, to ensure that the people involved in that terrorist act were in fact punished and did not get off on some kind of a legal technicality. So it doesn't happen often, but a case could be heard twice, both at the state level and the federal level. Okay, what I want to really focus on now for the rest of this presentation are some legal terms. So, the first legal term I want to make sure you know is the word indict. it looks like indict, but it's pronounced indict. And when someone is indicted, they are simply charged with a crime. So the state will indict someone. That means they're charging someone with a crime, and now that person is likely to go to trial. If a person is acquitted, that means that they went to trial, but the court found the defendant not guilty of the crime. Now, there is a difference here between being found not guilty and being found innocent. Courts do not find that people are innocent. They simply find that there is not sufficient evidence to suggest that they are guilty. So when you are acquitted, you are actually just found not guilty. It doesn't mean you're innocent, but it does mean that you're free. You no longer have to face prosecution on that particular crime again. Again, that would be double jeopardy if you did. Another term that you see in our Constitution is mandamus. Mandamus is the power of the court to mandate or require a specific action or to prevent a specific action from taking place. So, for example, you might have the court issue a writ of mandamus if let's say there is a law that's going to punish some particular type of activity. And maybe there's a court case that claims that this law is unconstitutional and should be stricken down as not enforceable. The judge might issue a writ of mandamus saying that we're not going to enforce this law until we determine whether or not the law is in fact constitutional. So a writ of mandamus is a mandate requiring a specific action or specific inaction on the part of, usually on the part of the state in trying to enforce laws. A criminal case is a trial in which a law has been broken. There is a crime that has taken place, and that trial will be heard in a criminal court, in a criminal court, and the court will be hearing a criminal case where the law has been broken. However, there are oftentimes cases that are held in courts which are not criminal in nature, and those are civil cases. A civil case is a trial in which no law was broken, but someone claims to have been harmed by the actions of someone else, or perhaps by the negligence of someone else. And again, I'll give you an example. Let's say my neighbor has a great big tree in their backyard, and that tree has limbs that are growing over my yard. And I might ask my neighbor at some point to trim his tree, because if a limb should break from that tree, it could fall on my house and cause damage to my home. Well, let's say that there is a storm that comes through one night, there's heavy wind, and a big limb is broken off of that tree in the storm, and it does in fact hit my house, and now I have to have $10,000 worth of construction work on my home to repair my roof. Well, I don't believe I should have to pay that $10,000. I believe my neighbor should, because he was negligent in not keeping his tree trimmed appropriately, and he was putting my property at risk by doing that, by failing to trim his tree. So I might ask my neighbor to help pay for this roof repair. He may refuse. In that case, I could sue him in a civil case. Okay, he didn't break any law, but I believe that he should still be held responsible for the damage to my property, because it was something of his that he could have taken action to prevent, which caused the damage to my property. Therefore, he should have to pay for it. That would be a civil case. No law was broken, but I was harmed by his inaction or negligence in this case. A couple of more legal terms. Original jurisdiction. Original jurisdiction is where a trial will first be held. Okay, sometimes we'll refer to a court as a court of original jurisdiction, where the trial is first going to be heard. Appellate jurisdiction is when we have a decision of a court being reviewed on appeal. So, for example, let's say someone goes to court for a trial. In the court of original jurisdiction, they may be found guilty. However, that person who was found guilty may say that his constitutional rights were not adequately honored in that first trial, and he may appeal the case on the basis of the fact that he believes his rights were not honored. He did not get true due process of law. And in this case, the court might agree that we should rehear this case with appellate jurisdiction. Okay, that means we're going to appeal the case. I want to stress that most cases never get to appellate jurisdiction. And you do not have grounds to appeal a case just because you don't like the verdict. You found guilty and you don't like that, you want to appeal it. That is not sufficient grounds to get to appellate jurisdiction. The only way you'll get to appellate jurisdiction is if it can be shown with reasonable certainty that your constitutional rights had not been adequately protected during the first trial. And in that case, you could potentially appeal your conviction. Finally, we have final jurisdiction, and that is the last place where a review of the previous court decisions can take place. So a court could go to appellate jurisdiction, and it could still conceivably get reviewed one more time, and that would be in the court of final jurisdiction. And the last legal term I want to talk a little bit about is just a general trial court. A general trial court is a court where the prosecution and the accused can each call witnesses and cross-examine the witnesses called by the other side. When you watch a movie or a TV show and there's a court case in that movie or TV show, almost certainly what you're seeing is a general trial court. You have the attorneys there, and you have the person accused sitting at a little table at the front of the courtroom, and witnesses are called. That's a general trial court. You have a jury, and the jury typically will decide your guilt or innocence in this case. A general trial court will always be the court of original jurisdiction. When it goes to the appellate courts or the court of final jurisdiction, you actually do not have witnesses called. You don't have the jury. You don't even usually have the accused sitting there at a table. Typically at the appellate level or final jurisdiction, it's more like a debate between the opposing attorneys, debating whether or not the rights of that person had in fact been adequately honored during that original trial. Okay, so that's a general trial court, the court of original jurisdiction. And with that, we're done with this presentation. And just as before, you do have an assignment with a worksheet, so go ahead and get started on that, and we'll talk to you later.